Hello, everybody. How are we all? I hope we're all great. Welcome to this Hines Legal webinar slash podcast slash really whatever you want to call it. But at the end of the day, it's about information, education, and getting people a bit more empowered in Strata about issues that matter. I am Chris Irons and I head up independent Strata consultancy firm Strata Solve. That's stratasolve.com.au. Alongside me, not literally, but virtually, is Frank Higginson, partner, Hines Legal and industry expert. Frank, welcome.
Hello, Chris. Hello, everyone, yet again. And nice and live. It's good.
It is good. It is good to be back in that zone. Look, just a couple of bits of housekeeping before we rip into today's content proper. Love to hear your questions, comments, thoughts, and indeed at one point today we'll be specifically encouraging a bit of audience participation. Stay tuned for that one. But in particular, if you've got a bit more of a detailed query, it's best that you use the link that will turn up in the chat very shortly. Put your details in there and someone will get back to you. And just a little bit about the broadcast. If you're new to the show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow us on Facebook, go to the Hines Legal page and hit the like button and icon. And for YouTube, hit the subscriber button and the notification bell. Today, an age-old chestnut in Strata, Frank. Improvements versus maintenance.
It never goes away, this one. And I think in my time, I suppose we've actually had some detail of the data. I think this has always been one of the top 5 disputes in the Commissioner's office, up there with pets and probably meeting corporate governance type stuff. I think that was that the case when you were there?
Largely, Frank. Yeah.
Just what is maintenance? What's an improvement? How does it get approved? At what level? On what basis? Spending limits? All sorts of things. And it becomes really emotive, I suppose, when people don't want something to happen, because this is a really, like all these things, a really technical thing. When you really drill down, like we want to put in a new fence, is what type of fence it looks like, what height the fence is going to go to, what color it might be painted or rendered, or how it's built, and all that sort of stuff becomes, in people's houses, very emotional.
Absolutely. And thinking about, because I think everybody who listens to us, Frank, would know I'm a bit of a word nerd. Think about the words here: improvement, maintenance. There's a certain amount of value judgment in those words, isn't there? Improvement, it tends to suggest something, whereas maintenance, I actually think, Frank, if you say the word maintenance, compare it to improvement, maintenance sounds like a lesser thing, doesn't it?
Absolutely. More of the same. And improvement, and this is, I suppose, the interesting thing in terms of an improvement. You could suggest that me getting more hair would be an improvement, but that's a subjective, stylistic thing. Improvement in the legal sense we're talking about today isn't so much that subjective, it's better, it's a change.
Sure.
And what type of change, and then degrees of change, isn't there?
Absolutely. And so I guess we're talking about this one today because it comes up all the time. So many disputes turn upon it, but we've had a recent decision, which we'll go into in a bit of detail today too, which sheds a new light on the maintenance versus improvement debate. So that's kind of our impetus for it. Let's rip into the discussion proper. So the best place to start, and unsurprisingly, it's probably always the best place to start, is with my old office. I didn't write this content either, so I'm not conflicted. From the Office of the Commissioner for Body Corporate and Community Management provides a really good overview of some of the basics of maintenance versus improvement. And we'll put that link up for you in a second. Let's try some general rule of thumb stuff then, Frank. So, maintenance, and back to that whole, the word. You look at that word and it's got that, if you break it down, it's got that maintain bit. So as you said, Frank, keep the same. At the same level, nothing substantially changed.
Absolutely. So in I suppose, Strata land, like for like would probably be another way to do it. So you're putting something that was back to the place it was, because of course things deteriorate over time and so on and so forth. But I think like today, we got a couple of cases we're going to talk about. So drill down a little bit in terms of well, that one decision of QCAT, and also another one that all knocked us off our feet at the time. I think probably some other general type rules you can have in relation to maintenance is you can, in terms of maintenance from a legal perspective, replace something with something new, provided that the thing you're replacing isn't available anymore. So if we've got a particular type of, this dumb example, particular type of glass, they don't manufacture these things anymore, we can replace it with another glass that's pretty close to what it actually is. So in that sense, it's not an improvement in terms of something new, but it's as close as you can possibly get to what it actually is. And replacement, maintenance in a legal sense for these things can apply to things that have broken down irretrievably, where they simply can't be repaired.
Yeah.
So I think probably they're the two sort of carve outs, because when we talk about what improvement is, you'll see the distinction there. So maintenance is not necessarily just painting the fence again. It can be replacing the fence if some of those conditions are met. They don't make this type of star picket. They don't do this type of render. And of course, I suppose that's a dumb example because render's never going to go out of fashion. Or the thing's not capable of being repaired. So that might be some sort of electrical apparatus. It might be a hoist or some style of lift or something that's in the common property that the manufacturer is not making anymore. So therefore, replacing that thing, which might otherwise be an improvement, is effectively maintenance.
And I think, Frank, this issue comes really topical right now. We're in this kind of general shortage of tradespeople and suppliers, for that matter, too. So increasingly, that idea that we can't necessarily source like for like is going to come up more and more, I suspect.
That is a really good thought bubble, mate, because I completely agree in terms of what's going on at the moment in terms of doing any sort of building work.
Yeah, it's I'm hearing stories that it's taking 10 to 12 weeks simply to get someone to come and quote, let alone do the work. That's bad news on a number of levels, but good news for those doing it. But anyway, forget about that. All right, so maintenance. We've talked about maintenance. Let's briefly touch upon improvement then. And again, we talked about this at the start and looking at the word. Something is made better, added to, improved upon, changed. But change, we're going to talk about change in a moment as well. There are particular kinds of change that we're going to talk about. And so, Frank, we're actually in luck because improvement is defined, is it not?
Who would have thought?
Who would have thought? Yeah. So maintenance is not defined in Strata legislation in Queensland, which is not helpful, but improvement is. And so reading it from the dictionary in the Body Corporate and Community Management Act, improvement includes A, the erection of a building, and B, a structural change, and C, a non-structural change, not helpful, including, for example, the installation of air conditioning. Okay, fair enough. Tell us about change then, Frank.
Yeah, and see, when I see that definition, and this goes back to, crikey, Introduction to Law, which for me was 1992, one of the real big things that they get you in to start with is the and, or, and includes. So when we're talking about, or when the legislation refers to a definition of improvement includes these things, they're examples. So it's not an exhaustive list. They're examples. So if you can, and I suppose, the erection of a building, quite obvious, that stands out to be what it actually is. A structural change, to me, that's probably a little bit less obvious than what the erection of a building is, but pretty close. I mean, something structural. That last one includes a non-structural change, which includes air conditioning, just leaves it so wide open to interpretation. It's not funny. Yep. And then I suppose, mate, and that's where into the Acts Interpretation Act, in terms of what change actually means. So change includes, this isn't an exhaustive list, to change by addition, exception, omission, or substitution. And I think when you look at that change and you look at what improvement means, improvement by its very nature doesn't necessarily mean something is better. We're talking about here in a strata context, something has potentially changed. And I suppose, as we all know, in strata land, it is really hard to get everyone agreeing with everything at the same time. So inevitably, particularly in bigger buildings, if you're talking about making an improvement to common property in some way, there are going to be people that don't agree that it's improvement in the subjective sense in terms of I don't like it, but in a legal sense, it may well be. And that is absolutely one of the confusing issues that comes up with this terminology.
Yeah. I think the one out of all of that that really sort of confuses me is the idea that change means omission. So, because to me, my logical brain goes change means you add to, but here, very much the definition is about no, you can actually lose something as a change.
So when in a spa.
Yep. It's a good one, Frank. It's a good one.
No, I had that. It's only because I had that last week. So it's
okay.
top of mind.
Okay.
What level of approval do we need for this? That's what you need.
Yeah. I think the interesting thing for me, as we said before, maintenance not defined, improvement is. So, Frank, that kind of means, doesn't it, that we define maintenance by not being improvement. That's pretty simple, isn't it?
Yes. And this is where, mate, unfortunately, lawyers make their money. Because this is a very, very subjective thing. So we've got, because when we're talking about what an improvement is, I don't think it necessarily, well, there's a bunch of grey. So we've got a definition, I suppose, in an ordinary dictionary sense of what maintenance is. We've got a definition of what an improvement is in a legal sense in the BCCM Act. Where the disputes all arise is that stuff in the middle that could be one or could be the other. Because I mean, some things in law, the old, if it walks like a duck and quacks like a duck, it's a duck, even if you call it a chicken. With these types of disputes and these types of issues, there is an enormous amount of grey in there. So, when we're talking about, and I suppose, mate, this is what we're talking about today in terms of the cases, particularly the adjudication decision. So, what is or what isn't, and as always, depends on the individual circumstances and depends to a degree, if you're going to have an adjudication on one of these things, what's just and equitable in the circumstances.
That's right. Well, when we talk about adjudications, the adjudicators have typically, as you said before, Frank, used the like-for-like approach as guidance. And if it is a like-for-like change, generally maintenance, and if not, improvement. It's absolutely not a catch-all by any means. So at this point, we're going to sort of shout out to everybody listening, and indeed everybody listening and watching after the event. Have you got some, and we've already got one question, somebody's reading our minds. Have you got a scenario, an example of, is this maintenance, is this improvement? Throw it at us and we will try and get to that before we finish up today. We'll try and go through those, putting us on the spot.
And dare I say to Jan, hello Jan, up in sunny North Queensland, could be one or the other, like an upgrade. So the use of the word upgrade could be maintenance, could be improvement. That's a little bit subjective in terms of the person using it, but factually, what is the type of work that is being done? It's really, that is a prime example of the grey that these things fall in between.
Indeed, Frank. So yeah, start throwing your improvements, feed maintenance scenarios at us, and we'll try and get to that. Okay, Frank, we've gone through all of that. So why do we care anyway? What does it matter?
Because these things are, you wouldn't call them DEFCON 1 situations in bodies corporate, but sometimes people do or don't like what actually goes on. But more importantly, I suppose, from that pure legal perspective, what type of thing, whether it's maintenance or whether it's an improvement, dictates the approval required, whether the committee can do it, whether it needs approval at general meeting, and if it is going to go to general meeting, what level of approval it actually requires. And of course, tied in behind that is spending limits. So we've got different committee spending limits where they do or don't need quotes. We've got general meeting requirements. And I suppose back to what Chris was saying before, talking as if you were in the third person, not here with me, mate, sorry. In terms of the unavailability of tradespeople and those sort of things and getting quotes, what we're inevitably going to be seeing, there's I'll deviate for a second off what we're talking about, but the 2 quote rule, if you're going to spend above a certain amount, subject to your building, you need to get 2 quotes. It might well be the case in the coming months, year or more, that you can't get a second quote. And so you can be, I suppose, relieved of the requirement to get that if there are exceptional reasons. The unavailability of tradespeople may well be one of those. So there's an application for someone in due course.
Absolutely. I think that's one, Frank. So you've gone through all of that there, Frank. useful guidance is available out there, but at the end of the day, that's all it is. And I think for all the reasons you just outlined, Frank, you will need some specialised advice if you want some distinct answers. And that's a really nice segue, isn't it?
It is.
Yeah. So we're going to talk about a recent decision of QCAT, the Queensland Civil and Administrative Tribunal. And this is relevant because it's QCAT. That means it's a precedent. Frank, what are we talking about here?
Well, we're talking about an appeal from an adjudication decision. So what we had here, building up in Cairns, what happened was an owner wanted to renovate their unit, as happens, which is fine. And in doing so, what they wanted to do was lower the window, in effect. So we've got a window that carves off here. They want to reduce it down by whatever. So in a building format plan, which all high rises effectively have to be, because you don't own the land, what as an owner you own is to the middle of the wall. Outside of that is common property. So the same with your neighbour on either side, you run through that way. When it comes to the external part of the building, inside bit's yours, outside bit's body's corporate. So that's why you don't see people going and painting around their windows and all that sort of stuff to create a different look, because that's actually common property. You might as well go and paint the driveway for all the legal ability you've got to do it. So what happened here was, and clearly this is always the case, things become important to people. Owner put up a proposal to the body corporate to improve their lot. And in doing so, what they wanted to do was lower that window. That was passed at general meeting. I think ordinary or special resolution, I forget which, apologies for that. And an affected owner appealed that decision on the basis that the lot owner, in conducting that work, wasn't actually improving common property, they were acquiring a piece of common property. Because when they effectively moved it into their window and created the view, they've suddenly created space that wasn't theirs. So what they've done is actually acquired something from the body corporate. So there was a bit of improvement versus maintenance in here. And I suppose the interesting thing for this one, for me, because and it's the same as the smoking decision on hazard. You see these words, you see nuisance or hazard, you focus on nuisance the whole time because that's where the disputes have been, and suddenly hazard appears and wacky do. In terms of this one, we would always have operated on the basis of it's an improvement to common property by a lot owner, when actually it's not, because what the lot owner was doing in acquiring that space, or creating that bigger window, was effectively acquiring that space for their own use. And so what the member in the appeal jurisdiction of QCAT decided here is that required a resolution without dissent. So it's no different to getting a grant of exclusive use, or buying a piece of common property, or transferring a bit of the yard to you. That is a disposition of common property. That is the body corporate giving away the right to use that area almost forever. So, and the member here said, and probably we'll put up a link to the case so everyone can have a good read of it if you want. You get sort of about 3/4 of the way through, and as always, they get into the detailed reasoning. But the member here said that a lot owner's interest in the common property will not be taken away lightly without body corporate approval. So it's particularly so if there's some demonstrable loss, not just bricks and mortar, to an objecting lot owner, to the obvious benefit of the acquirer. So what happened here is the external facade of the building was changing. That's what happened. So suddenly you've got a facade that has everyone's window looking the same, and then suddenly it's not going to be anymore because of this particular piece of work. And ultimately, the loss may impact on a lot owner's interest on the interest schedule entitlements, because that's the value of the lots, but there's no evidence of that here. So really what the member here has said is that by collecting that little bit of space, even though it could be characterised as an improvement to common property in one way, it's actually the acquisition of the common property by that owner, or another way to look at it, the disposal of that common property to that lot owner, and that requires a resolution without dissent.
There's that word thing again, Frank, disposal. Yeah.
Yep, absolutely. And the interesting thing here is, I think, handled right, this owner will still get there. Because the thing is that when you come to resolutions without dissent, so this is part B of, I suppose, the decision, when you look at it and go, hang on a minute, what happened? Owners or owners in terms of motions that are resolutions without dissent can't cast their votes unreasonably against. that particular resolution. So the Commissioner's Office has the ability to cast aside, for want of a better phrase, owners' votes which aren't cast reasonably. So an unreasonable one might be, I'm only going to do that if I get paid 50 grand. Well, no, that's not a rational basis. So really what should happen here is the owner needs to go back, potentially, try to ratify the acquisition of common property by resolution without dissent. Inevitably, there'll be a fight because some people are going to vote no. If you've gone to the expense of appealing the decision to QCAT, you clearly feel quite strongly about it. And to me, what this owner needs to do is actually offer to pay the body corporate for what they've acquired, the value of that area. Because to me, it's probably quite a reasonable objection for someone to say no when someone has acquired a piece of common property and not offered any consideration for it. Like, in which world is that commercial? So I'd say this one's probably got a little way to go yet, but it's a really interesting one just in terms of that. It's not an improvement, it was an acquisition / disposal, which is a higher threshold.
While we're talking about decisions, Frank, let's try one other very quickly. This is an adjudicator's decision. And this is about, put the link up to it, this is about paint, Frank.
It is. And I know we're running a bit behind, so I'll smash this one out. The decision's there for everyone to look at. And if you want to Google the name of this building in the Ostley, you'll find there's lots of decisions. Big buildings.
Sorry, leap in, Frank. We're having a few problems linking, apparently. We will get those links to you afterwards.
Yeah. Cool.
Sorry,
well, Admiralty Towers 2 was this one. So what happened here is the body corporate need to paint the building. Fine. Statutory obligation. This is a true maintenance versus improvement argument. So it needs to paint the building. And previous decisions had been along the lines of, let's go to the owners and get the approval to paint the building. Let's go and get the authorisation to spend the required money with the required quotes, but let's leave the committee to decide what colour they actually want to use. So this is one where that typical approach had been adopted, and the argument, I just love the way they come up with paint names. They wanted to change the paintwork to be Knapsack, Kahlua Milk, and Grand Piano. So there's some creative fellow consultant in at Dulux that come up with those names. And so what happened was the committee went and polled the owners. So they didn't actually have a general meeting. They left a box in reception and said, let us know what colour you want. And people could drop their notes in or whatever. And then the committee made a decision to say, well, let's paint it this particular style. And a group of owners objected. And they won in this particular instance. And in this one, and this is an example of upgrade again, changing the colour scheme from what it was to these new colours was an improvement. So it was a change. And the adjudicator, said even so, such a dramatic change as envisaged, clearly to give a modern look to the facade, is intended to be an improvement in the ordinary sense of the word, which requires a special resolution. An improvement does not need to be a change for the better. They specifically made that observation because clearly people didn't like that colour scheme. So the question of aesthetics gets left to lot owners, and ultimately what that decision said, changing the colour scheme should be approved by special resolution. End of story. So maybe now you do it as a motion, same issue motion, not motion with alternatives anymore, and away you go from there. Because at the time, that upset what was ordinary practice. Committee can decide, but owners control the spending. Now it's both with the owners.
Well articulated, Frank. Those are two good cases for people to have a look at. I know there's a lot of amateur lawyers out there who like that sort of thing. We'll have those links in the chat a bit later. All right, well, conscious of time, where does that leave us? Well, it leaves us in the usual place with most Strata things. It's open to interpretation. Surprise. But I think more to the point, though, you don't want to be making definitive calls on that's an improvement, that's a maintenance issue on a wild guess or a whim. Because as you've highlighted really well in that QCAT case, that's where it gets to ultimately. Imagine all the money and time that has been expended on that stuff.
Yeah. And mate, again, to colour it, in terms of quotes have currencies of 30 days these days. You get dragged into a dispute in the Commissioner's office, it's going to last 10 months. Who knows what's going to happen to the pricing? So, you know, and I suppose in that sense, if it's black and white, for want of a better phrase, so if we've got a fence paling and we're replacing it with the exact same fence paling from Bunnings and we're painting it the exact same off-white that it, and this is always one of Chris's phrases, you've got to take the temperature of the building and the temperature of that particular issue. And if you think it's going to be contentious, then you've got to be really sure that you're right.
That's right, Frank. And I guess to sort of articulate that in a slightly different way, you start at the start. Is there enough information to be able to make a determination? Great, do it. If not, get it supplied or request it. Are there any directly relatable cases? Is there something specific in the modules or the Act which relates directly? If so, well and good. If not, that's where you run into the ambiguity that we've been talking about, and that, you know, that's where you will need the specific advice. And then importantly, once the advice is to hand, you need to act upon it the right way. Yeah. See
And
too
I think
many
in that
instances.
Admiralty Towers painting decision, the adjudicator actually commented that the committee had got legal advice and unfortunately then tore it to pieces in terms of disagreeing with it. Because that was based on what the previous decisions were. So, and that's another example of what can go on in the Commissioner's office in the sense of they're not bound by precedent. So just because that thing has been decided in a different way previously doesn't mean it's going to continue to be done that way.
Absolutely, Frank. Well said again. Query from Thurston Howell, the fourth. Great name, Thurston. So one of your scenarios, fire doors replaced in a different look and feel, not complementary to prior and other style in the building. Well, I'll go first and hand over to you, Frank. Immediately, I think to myself, what does complementary mean there? What is other style? What is different look and feel? There's way too much ambiguity there, Frank.
And there's a bunch of grey. That is absolutely the grey area that we're talking about. So, and so why? Why are they different? Are they different because the fire doors that were used in the construction of the building 30 years ago aren't available, or have standards changed? Does QFES require something different now? And that different is this specific requirement, because to me, that would be another carve out in terms of making that maintenance as opposed to improvement. So they're the two immediate things that jump out to me.
Absolutely.
But that's the grey. So there's the factual matrix in there, and I suppose there's almost a checklist in my head I can see coming up. But you'd need to tick the box on those things to decide which way is which.
It'd be great to have a checklist for this sort of thing, and it's interesting the Commissioner's Office do that kind of stuff when it comes to bylaws and one or two other things. This is one thing they would not do a checklist on. And I think that tells you the level of subjectivity and ambiguity. I mean, you hit the nail on the head before, Frank, that idea of aesthetics coming into play and leading people in a direction that maybe they shouldn't be led in. We have just about come to the end. Just a reminder to everybody again, if you're new to the show, live stream to YouTube and Facebook every Thursday at 2 p.m. Brisbane time. That's 2 p.m. Brisbane time. So to follow us on Facebook, go to the Heinz Legal page, hit the like button and icon, and then on YouTube, hit the subscribe button and notification bell. We'll be publishing some show notes post-webinar podcast today, and we'll give you our top 3 takeaways and the links that we spoke about today. But Frank, we've come to the end. As always, it's been another
illuminating
topic. Very illuminating. Thank you, Frank.
And look, this has been an issue for years and will continue to be an issue for years.
Yeah, absolutely. And thanks everybody for tuning in. A lot going on in the world. So thank you for taking the time to be part of this one. We'll see you next time.
Thanks, everyone. Bye.
See you all. Bye.